What are the responsibilities of the beneficiary of a transfer on death, TOD, deed? Have you ever wondered what happens to a property when the owner passes away? Specifically, what does a beneficiary of a transfer on death deed need to know? Let's break it down. A beneficiary holds a future interest in the property, which only takes effect after the property owner, known as the grantor, has died. Until then, the beneficiary has no rights over the property. First, the beneficiary must survive the grantor. Typically, this means they need to outlive the grantor by a specific period, often 120 hours or 5 days. If the beneficiary does not survive this time frame, the property may be passed according to the grantor's will or state laws regarding inheritance. Next, once the grantor has passed away, the beneficiary inherits the property but also takes on any existing debts tied to it. This includes mortgages, liens, or other claims. The beneficiary must manage these obligations, which may involve continuing to make mortgage payments or settling any liens. Another responsibility is to ensure the grantor's death is properly recorded. This involves submitting a certified copy of the death certificate along with the transfer on death deed to the county recorder or land records office. This step is crucial for officially transferring the title of the property. Once the title is transferred, the beneficiary can manage the property as they see fit. This includes selling it, renting it out, or even refinancing any loans. However, they must also be prepared to pay property taxes and maintain the property. Tax implications are another important aspect. The beneficiary may face capital gains taxes if they decide to sell the property. These taxes are based on the property's value at the time of the grantor's death. Consulting with a tax professional can help clarify any potential liabilities. It is also essential to know that the beneficiary is not required to accept the property. If they choose to disclaim the inheritance, the property may go to alternate beneficiaries or revert to the estate. From an elder law and estate planning perspective, understanding these responsibilities is vital. Beneficiaries should be aware that their rights do not begin until the grantor passes away. They must be ready to handle any financial and legal responsibilities that come with the property. In practical terms, beneficiaries should keep track of the grantor's health and any legal documents related to the transfer on death deed. Preparing for the financial responsibilities of property ownership is key. Consulting with an elder law or estate attorney can help ensure a smooth transfer process and clarify rights and obligations. This preparation allows beneficiaries to manage the property effectively and comply with all legal requirements once the transfer occurs.